I'd like to thank my colleagues for their contributions and for their fulsome support for the 31st Amendment of the Constitution Bill, which we've been debating and discussing here over the last couple of days. Deputy Connaughton, you're absolutely right. It is now about communicating it properly to the public. That is extremely important. It's been very interesting to see the cross-party support that has been in the House, and I want to welcome that. And as I did when I introduced the bill, I began by saying that I wanted to thank everyone from across the political divide who had contributed so much to the development of the amendment which I am now proposing. And I do want to just briefly reflect on that for a moment again, and to pay tribute to the All-Party Committee under the chairmanship of former Deputy Mary O'Rourke. A huge amount of work was indeed done by that committee. Also to colleagues like Alan Chatter, who have spoken about this issue for 20 years and have highlighted the need for change. And indeed, the former ministers who have been mentioned a number of times here, former Minister Brian Lenihan and Barry Andrews, Mary Hanafin. And to say that so many people have contributed to the development and the thinking around putting children at the centre and the need for change. So many of those who have suffered directly have spoken out, and by their testimony, their courageous testimony, have impacted on the debate which we've had here over the last number of days. I'm very struck by the contributions made in this House, indeed by the personal stories of many people, many deputies who've had experience of adoption and fostering, who have had direct contact with families who are suffering, who have seen abuse in families who have come to them and who've dealt with very complex issues in care proceedings. And I think the debate has been reflective of a changed reality in Ireland, a change in society's understanding of children. And we've seen debates like this before. I think when homosexuality was decriminalised, we've seen it when the Second Commission reported in 1992, when we had a debate in this House. And again, I think what members across the House were very clearly saying is that this change must be reflected in our Constitution, and giving very strong support to the kind of changes which the Government is proposing. And I want to thank all members for the care they've taken in relation to this debate, and the detail and the quality of their contributions indeed to the debate. I said the other day, Cancoli, when I introduced this bill, that constitutional change gives us a rare opportunity to look at ourselves as a nation and ask if we are truly espousing correct values. And it does give us the opportunity to assess what we stand for. And ultimately, constitutional change allows us to consider future generation and ask what Ireland should they live in. Well, I think those questions have been comprehensively answered by deputies in this House here. Equally, deputies have been very clear that when we look at the record in relation to children in Ireland, and the most vulnerable children, we have been found to be lacking, and we have been lacking at a constitutional level. So when I put the question the other night, do we believe that the way children were treated in this state represents what we believe to be the values, morals and ethics of the Irish people? The answer from this House was a resounding no, and that we did need to change, and we do need to change that. A whole range of issues were raised by deputies, and I do want to address some of those. A number of deputies raised questions in relation to the language that's in the amendment. Of course, every word, as the Attorney-General, who has done so much work on this amendment and her staff, every word, as the Attorney-General says repeatedly, that is put into the Constitution has a meaning and will be interpreted, if it is passed by the people, to have a meaning and will be interpreted. And we don't know, we cannot be absolutely sure, of course, at this point, how those courts, and I think Deputy Connaughton made that point and said we do not know precisely how this language will be interpreted, but we can say that the balances we are trying to achieve are important. They're about balances between the family, the child, getting the correct balance for those children who are in need of protection, ensuring that the state can intervene when it needs to. And to go over some of the words which we use the word imprescriptible. And imprescriptible in the context of rights means rights which cannot be lost by the passage of time or abandoned by non-exercise. Natural rights are personal rights that we enjoy by virtue of our humanity under natural law. And in G versus on Board of Clawla in 1980, the Supreme Court considered what are the natural rights enjoyed by the child. Of course, the Supreme Court, or a Supreme Court in the future, could and most likely will interpret the first article. We do not know quite precisely how it will interpret it, but undoubtedly it will be interpreted. But certainly what we seek to do is to give strength to children's rights by what we have put into Article 1. The best interest principle is already well established in Irish statute law in the Guardianship of Infants Act 1964, the Childcare Act 1991 and the Adoption Act 2010. And this referendum seeks to give constitutional strength to this principle as provided for in these laws. The amendment as drafted mandates the Oireachtas to legislate for the attainment of children's best interest. This means that the test of best interest may be further prescribed by law by the Oireachtas, and of course it now carries, if it is passed, constitutional strength and gives a greater counterbalance than heretofore as against other expressed rights in the Constitution. By specifically and specially recognising the best interest principle within this article, it provides an important balance to Article 41. Therefore, the new article is a powerful tool in the hands of the Oireachtas to legislate for children's best interest and to balance them appropriately with the rights of families under Article 41 and birth parents under Article 43. I also want to draw attention again to the use of the words any and all with respect to children. The intention is that in each place that this formulation is used, that all children of marital and non-marital families will be treated equally when it comes to protecting their safety or welfare, their access to adoption and consideration of their best interest and views in key proceedings. I have been asked about the legislative change that could arise following this amendment, if the people support this. The changes, there are a number of areas clearly where there is a need for legislation. I've already published the general scheme in relation to adoption because I've taken the decision to publish that bill because the change proposed is a significant and highly sensitive one and deals specifically with constitutional rights of a number of parties in those proceedings. Additionally, it is my intention to, within that law, and I do want to inform deputies of this, that the best interests and views of the child elements reflected in the amendment are brought fully into the new adoption legislation. In respect of other areas of law, as has been pointed out in a number of areas specified, best interests and the views of the child are already provided for, albeit in a number of different legal formulations, but with the same impact and intent. The explicit inclusion in the amendment bill of reference to these matters puts it beyond doubt that this House has the capacity to legislate for those matters. I will, of course, be bringing forward legislation in relation to the Child and Family Support Agency, and following that I have to further and will further examine the Childcare Act in its entirety to ensure that it reflects to the fullest degree possible the reforms in practice and processes which are part of a modern integrated child and family delivery system, as well as reflecting fully in all of the relevant areas the principle that the best interest should be the paramount consideration in childcare proceedings. I also will look at the guardian ad litem services under the Childcare Act 1991, with a view to ensuring that the service is better structured and regulated and provides improved value as well into the future. I do want to point out to deputies as well that in the programme for government there is a commitment to reform and modernise aspects of family law. And in this context, the detailed recommendations of the Law Reform Commission's report on the legal aspects of family relationships and guardianship rights are under consideration in the Department of Justice and Equality with a view to preparing legislative proposals. Also under consideration is whether existing provisions under the Family Law Code should be amended to better reflect proposed constitution provisions on the rights of the child in relation to the best interests of the child and hearing of the child's view. And there may be other areas of legislation which will arise following this amendment. It is clear from the debate in the House that the issue of adoption is one which strikes a chord with many in the House and outside of it, and I want to be very clear on the intention here. It is not to support or advocate the wholesale adoption of children from care. Far from it. I am clear in my mind, and the legislation we have drafted reflects the position, that this provision will be for the benefit of some children in care. Clearly, not all children in care. Many children come into care for very short periods, go back to their families. Care is used as a family support for the family, and that, of course, will continue. But improving assessment, care planning and matching children into stable care placements has to be a key priority for us. When you examine the child death report and you see the kind of movement in and out of care that many children have, clearly we need improved assessment, better permanency planning, better care planning and better placements for many of those most at risk children, to make sure that they benefit from the stability of care, even when adoption is not the preferred option. This is very important. And it is not, of course, as I've said, for all children in care. However, for some children in care who are eligible for adoption, this is an extremely important amendment. And I think deputies across all sides of the House have understood that and addressed that issue. I do want to point out as well in the draft bill the very carefully balanced changes which are being proposed, not reflective of not only the changes proposed to the Constitution, but to the existing rights of all parties in adoption proceedings under Article 40, 41 and 42 of the Constitution. And there are very detailed notes available on this. I want to be completely clear on the process that is involved in a child being adopted from care as well. The details are contained in the draft bill, the process and the sequencing, the specific tests to be met, and critically the safeguards for the child and the parents which apply and will continue to apply in the area of adoption. They're well explained in the material I have made available publicly, and I hope that that will become further known in the country as people get closer to voting in November. Specific questions were raised by a number of deputies about counselling for adults proposed to place their child for adoption. And I do want to reassure deputies that under existing law, Section 14 of the Adoption Act, a mother or a guardian who agrees to place a child for adoption must be counselled and given full information about the adoption process before the child is placed for adoption. An authorised person is specially appointed by the Adoption Authority to ensure the parent's consent is full, free and informed, exactly the same as in inter-country adoption. Without consent to the placement of a child for adoption, a voluntary adoption cannot proceed under any circumstances. This process will be retained following the proposed amendment to the 2010 Act. Deputies also raised, I think Deputy Troy, you raised this, the issue of foster care payment, and if a child was adopted and the parents who were previously foster parents then became the adoptive parent. I do want to point out that the Child Care Act 1991 provides that where a child is adopted from care, the HSE may contribute to the maintenance of the child as if they continue to be in foster care. This provision gives some scope, in a limited number of circumstances, for the HSE to acknowledge the financial burden that might arise for some families should the foster care allowance be discontinued from the moment of adoption. It is an exceptional provision, but it is available for those situations where the continuation of some financial supports might be required in the short or medium term due to the particular circumstances of a situation. I was also asked if the general scheme of the draft bill represents the final draft that I expect to bring to the Houses, should the amendment to the Constitution be accepted by the people. The draft sets out the policy of the government. The only changes I would expect will be those of a technical change nature required to bring greater clarity to the legislation that might emerge. Changes that might be required to strengthen the bill further, as I've said, with particular regard to the general provisions in adoption law regarding the best interest principle and the views of the child in the various proceedings under the Adoption Act. I can say that I do not envisage any change in policy from that set out in the draft and the information and explanatory notes already made available. There was a lot of discussion from deputies in relation to how services for children are being delivered, what services are available, and what is the future of children's services in this country. And of course I agree that the referendum is not a panacea. The referendum is one aspect of our approach to strengthening child protection and children's services in this country. But of course, there is a much bigger picture which needs addressing. That is why we have an ambitious programme in relation to child protection. We have an ambitious programme in relation to legislation and changing the way we deliver services. And deputies present in this House, we had an opportunity yesterday to discuss those reforms in detail and the development of them. But I certainly take the point that there is ongoing work to do in relation to the organisation of services for children and families and the development of services. And of course we're doing that at a time of limited resources. Of course, over the last 10 years there were huge resources available and we didn't deal with some of these challenges when in fact there was a lot more money available. But certainly we need to examine how we are delivering these services, and we do need to take a reforming approach to them. And deputies will know the work we are doing in that area. But of course resourcing is an issue across government and there are difficult choices to be made. But I do remain committed to ensuring that we make real improvements for children in the lifetime of this government. And I am also determined that the new agency is significantly different, both in terms of political accountability and delivery of services, to what has gone before, and that it is sufficiently resourced to achieve the improvements that are essential. I want to finish, Cathaoirleach, by reiterating my thanks to the House for the support I have received in respect of the bill. I was struck by the sentiments expressed by so many in this House during the course of the debate. Deputy Troy spoke about every child in this state will get what he or she deserves, namely a loving and meaningful childhood. Deputy O'Quailon spoke very movingly in relation to this constitutional amendment, giving all voting citizens the opportunity to say stop to the abuse and neglect which has characterised some of our past and which has been so horrifically really detailed in the reports with which we are all familiar. And there is no room for any complacency. There is no doubt that eternal vigilance is the price of ensuring that children are not abused in current times as well. I really want to welcome the cross-party support which I have received. As I say, I think we all have a very big job to do now in terms of ensuring that the kind of debate which we heard here in the House over the last few days, the kind of detailed information which was shared, the kind of understanding which was shared, we need now to ensure that we communicate that to the citizens who will have the opportunity to vote on this in the referendum in November. And I'd like to thank all deputies for their contribution during the course of the debate.